And let's move on to our last panel, which is finally current topics in international construction arbitration. So something slightly, certainly more familiar to me. It is with great pleasure that I introduce our chair for this afternoon, Alexander Gunning KC of 1 Essex Court Chambers. Alex is an advocate specializing in complex, high-value international disputes, predominantly in arbitration. He's acknowledged in all the directories for his expertise in cases concerning large energy and offshore construction projects and natural resources. He has been leading counsel in disputes concerning a series of high-profile infrastructure projects, including the Kashgan offshore oil field project, the Marmaray rail project, and the South Stream pipeline. And he has a particular interest and experience and expertise in disputes arising out of the East and Southeast Asia region, and is a UK representative for the Inter-Pacific Bar Association. So, Alex, I now hand over to you for the panel. Thank you.
Thank you, Renato, and hello, everybody, and welcome to the final session of this two-day conference. If the conference has been your sort of personal Camino de Santiago, you have now arrived at the Parador, and so you can relax and unwind. We have to mix my metaphors now, a game of two halves. We're going to cover current topics in international construction arbitration, and we have three different topics. The first topic is insolvency, and that is obviously with the problems that are being faced in the supply chain at the moment, likely to be a very relevant topic to arbitrations that are on foot or imminent. We are then going to touch on two different topics. One is the use of AI in construction dispute resolution, and the other relates to in the future of construction investor-state arbitration. Both of those also very current topics. Let me. What the plan is that the first two speakers will cover insolvency, and then we'll see where we are. There might be time for questions then. If not, we'll then move on to the other two speakers. But so let me introduce you to our first two speakers. The first is Dr. Manuel Penades, who is a reader in international commercial law at the Dixon Poon School of Law, having joined King's in September 2016. Before joining here, he worked at King's dreaded rivals, the LSE. I don't mention their name here. As a former graduate of this university myself, I know how hated the LSE is, as well as the University of Warwick and the University of Valencia. Dr. Penades is a qualified solicitor and an abogado in Spain, and before his academic career, he worked at WilmerHale, I think, and clerked at the Commercial Court of Valencia. He regularly acts as a consultant or expert witness in disputes. His research work focuses on international arbitration and cross-border insolvency law, and he's recognized as one of the world's leading experts on the effects of insolvency on arbitration, and as such, he was selected to act as the academic chair of the IBA's Insolvency and Arbitration Project, which produced a set of invaluable reports on the effect of insolvency on arbitration. In addition, his doctoral thesis was cited twice, so far as I could see, in a leading authority on the topic in the Del Fuego booking case in the Commercial Court in Santander in Spain. And for those of you with an interest in the football on Sunday, I should perhaps mention that he has experience on contracts between FIFA intermediaries and players in La Liga and the Premier League. To my immediate right, Professor Crengutza Leoa is a partner at LBDP in Bucharest, Romania. She acted, I think, for Romania in its successful defense of the ICSID claim, about 5 claims brought by the Mikula brothers. From 2015 to 2018, Professor Leao was vice president of the International Court of Arbitration at the ICC in Paris, and she remains a member of the ICC Commission. She is a very experienced arbitrator, having acted, I think, in over 130 cases. And for a number of years, she has been recognized as a thought leader in arbitration by Who's Who Legal, and is described in the current edition as a brilliant construction lawyer. She's a visiting associate professor at Bucharest University Faculty of Law, teaching international comparative arbitration and construction arbitration, and an associate professor of business law and EU law at Bucharest University of Economics. Now, they are going to be addressing you on the effects of insolvency and arbitration, and they're going to be splitting it up between themselves. So without any further ado, I'll pass over to Manuel.
Hello. Yeah. Thank you very much, Alexander, for the introduction. It's a pleasure to be here. So let's just start with the basics. That might be quite basic for many of you, but just in case, to make sure everyone's on board. The concurrence of insolvency and arbitration in the very same international disputes bring together a clash of regulatory principles. If we look at this slide to the left, we have the arbitration core principles, which are basically, it's an individual procedure between the parties that have signed the arbitration agreement. Insolvency, in contrast, is by definition a collective endeavor. Arbitration is generally confidential, whereas insolvency, I apologize, is frequently public to allow creditors to join the collective procedure. Arbitration is again out of court, whereas insolvency is court-driven, or at least driven by a professional appointed by the court. Arbitration is about enforcement of actions individually, whereas insolvency is characterized by the impossibility to commence and carry out individual enforcement actions in order to maximize the collective interest. And finally, arbitration is paid justice, whereas insolvency is characterized by the absence of sufficient funds to comply with obligations as they become due. So someone could say that from this contrast of regulatory principles, the coexistence of insolvency and arbitration could prove fundamentally impossible, so that the US Court of Appeals, the Second Circuit, has said that this is a conflict of near polar extremes. Now, I'm aware that different legal systems regulate this coexistence in very different ways, and primarily this diversity of solutions will be one of the issues that we'll be addressing in our presentation today. But you could also see from that collision of principles that insolvency appears to have a much stronger public importance compared to what arbitration is intended to protect, which is the interest of those private parties involved. So that could be, in principle, a very easy solution as to which one should prevail. What happens, however, is that this interaction between insolvency and arbitration does not always take place in the same set of circumstances. Sometimes insolvency commences first, and the question is whether arbitration can be commenced by the insolvency trustee or against the insolvent estate, and the question is whether arbitration can commence and continue in those situations. In other instances, we already have an arbitration ongoing, and the question is whether insolvency, when once is open against a party involved in arbitration, has any impact on the ongoing arbitration as to whether it has to come to an end, it has to change the nature of the arbitration, or is just business as usual. And finally, we have situations in which arbitration has already led to an award. Then insolvency proceedings are open, but that award has not been complied with. And the question is, where can we enforce the award, or how is that award a sufficiently successful proof of credit to join the queue of creditors in the insolvency proceeding? So we have a different constellation of situations, and the solutions are not always the same. But one thing that we can identify, at least, is that in the first two, we have both arbitrators and courts, which have to identify which one will prevail. And I don't mean which one in terms of courts or arbitrators, but insolvency or arbitration. We know that courts can intervene on an insolvency capacity or in an arbitration-related capacity for setting aside actions or enforcement proceedings. The ultimate question being, is insolvency a bar to arbitration? And if it is, can it be used and sometimes abused to stop arbitration? And when it comes to the third scenario, if the New York Convention, as this very pro-enforcement framework which facilitates the effectiveness of arbitration, allows to trump those insolvency concerns, is de facto an arbitration agreement, a pseudo-security, which allows you to obtain a higher level of satisfaction of your credit than if you had not had an arbitration clause in your contract. Can you escape those pari passu or equality of creditors limitations which govern the insolvency setting? Now, Very briefly, when in any of those constellations, and especially when arbitration proceedings are ongoing or are considered to be commenced, there are issues of jurisdiction and issues of procedure. But there's also a more pragmatic approach, which is, where is the money? That is, can I actually commence arbitration? In the sense, can I fund the arbitration? Does it make any sense to arbitrate against an insolvent party? And if I win the arbitration, what do I do with my award against a party that doesn't have apparently sufficient assets to cover its liabilities? Now, Krengute is going to address some of those jurisdiction and procedural questions from a civil law perspective. I will provide the English approach very briefly, but before I do that, I will identify some of those issues that arise in the context of jurisdiction first. And the first issue is, does the tribunal have or preserve jurisdiction to decide the merits of the claim? And that can lead at least to 3 different questions. Is the arbitration agreement valid and effective or operative? Is the dispute arbitrable? And here we can not just deal with ordinary commercial or contract disputes, but also setting aside actions, avoidance actions, transactions under value. That's causes of action which the insolvency regulation itself, or the insolvency regime, provides, and which did not exist prior to the opening of insolvency proceedings. And the third question is that, is the insolvent party capable of arbitrating, or to arbitrate, or is that something that has been lost as a consequence of insolvency? Now, some of those questions might have very clear answers from the point of view of English law, but I can tell you that they are not clearly answered in many jurisdictions, and when they are answered, the approaches across the global comparative level are very, very different, which will trigger conflict of laws questions, as Krengute will assess in a second. Secondly, even within jurisdiction, is how far does the jurisdiction of the tribunal go? The first thing is the question in dispute covered by the arbitration clause, and here we have Fiona Trust and a very wide interpretation of arbitration agreements, but not every country has that wide interpretation of arbitration agreements, especially when the cause of action lies with the insolvency legislation. Second, what type of relief is the arbitral tribunal allowed to provide? Can we still order condemnatory award or issue condemnatory awards? Do they have to limit them to declaratory awards? And we see, for instance, that France has a very strict approach on this, and we can discuss that later. And also, what about compensation of credits? And I'm aware that the set-off and adjudication was a very major issue before the Supreme Court here in 2020 with Bresco, but similar considerations happen in arbitration and insolvency when one party is trying to enforce de facto their claim within the arbitration proceedings, and not every country will allow a set-off or a compensation because de facto amounts to a violation of the equality of creditors that might be imposed by the insolvency proceedings. Not every country accepts a set-off that England does. And finally, what about interim measures already adopted or that will be adopted or are requested later on? Insofar, an interim measure to some extent secures a future enforcement action. What about situations where, by definition, individual enforcement actions cannot be adopted? Does it make any sense to preserve those interim measures adopted prior to the opening of insolvency proceedings? And my last slide before Krengute kicks in, even if it's business as usual, even if we answer in the affirmative all those questions and arbitration can go ahead, that doesn't mean arbitration will continue as business as usual. There are procedural adaptations that need to be put in place in order to respond to the insolvent reality. One is, what's the role of the insolvency practitioner? Does it replace or coexist with the insolvent party? And if so, what if they have conflicting messages within the arbitration? Second, can we suspend temporarily the arbitration so that the new insolvency practitioner becomes familiar with the content of the arbitration? And what is the right level of suspension that we need to provide in order to protect due process rights and to prevent precisely that type of violation? Third, what about conflict of interest? Do we need to reassess new conflict of interest between the existing parties and the administrators that have been appointed? Issues of confidentiality, given that now we have a collective interest on what is the outcome of the arbitration, because that has an impact on the patrimonial value of the insolvent debtor. And finally, security for cost. So as you can see, the menu is really wide. And in order to address some of those questions from a civil law perspective, I think Krengute can provide us a very good view.
Thank you, Manuel. I hope you can hear me. I have been confronted in the last 20 years with a number of disputes in which I honestly can say that my imagination was developed by insolvency more than it has been developed by poetry. Because it has been every single one surprising. On one hand, because it was a blend of views from different jurisdictions in the council perspective, then in the membership of the tribunal. Then the place of arbitration and the approach of courts at the place of arbitration for the annulment proceedings differed from the approach of the courts at the place of enforcement. And public order issues were involved in both cases when speaking about insolvency. The problem with insolvency is that actually it affects three fundamental freedoms that are required for an arbitration proceeding to be effective. First is the freedom to enter into an arbitration agreement, the arbitrability from the point of view of the party who enters into such agreement. Then is the moment in which arbitration takes place, and that would be the freedom in terms of the permission of the state at the place of arbitration for that arbitration to continue at the time that it is initiated. That is a matter that normally is in a way or another related with the inoperability. And then is the freedom of a party to enter into agreements that would be of relevance to the arbitration itself, like for instance settlements or other type of agreements, including set-offs sometimes, which may include an element of a volitive element, an element of will. So if we think at these elements, we understand that this is really some area of fun for lawyers, but not necessarily for the parties. What are the main, I would say, categories of issues that I have been confronted with? And the jurisdictions that I'm most familiar with are Romanian, Austrian, Swiss, French, and Italian. So this is where my practical experience comes from, as opposed to Manuel. I'm not an academic in the field of bankruptcy. I'm a practitioner and an academic in the field of arbitration. So, a matter of jurisdiction, would the impact of opening of the insolvency proceedings may be a matter of jurisdiction? Here, the problem that I have been confronted with was that the perception, or the perspective rather than the perception, the perspective was of a clash between the jurisdiction of the syndic judge once that the insolvency proceedings are open, which is perceived as an exclusive jurisdiction, overriding any kind of jurisdiction choice the parties might have had before the launch of the insolvency proceedings, that might make the arbitration agreement inoperable. And then the problem is, even if that phrase would be true, as the question is under which law, and whether that law under which this phrase is true is applicable or not in the case of arbitration. Because, for instance, the law of the arbitration agreement may be different than the law applicable to the insolvent party, where actually we do have the court that would prevail in the logic of the insolvency law over the jurisdiction of an arbitral tribunal or any other kind of choice of jurisdiction. We can even conceive, but I have been not confronted with this situation in which the law at the place of arbitration would have been considered relevant. That normally in the case of exclusive jurisdiction of the syndic judge was not on my agenda in the cases, with this limitation, in the cases that I have been confronted with. So answers were different, as I mentioned, in between the decision of the tribunals, the position of the courts at the place of arbitration in the annulment proceedings, and the position of the courts at the place of enforcement, if the place of enforcement was actually the country in which the party who was under insolvency proceedings is domiciled. Then the other question is whether we have a matter of subjective arbitrability that enters into place in the moment that the insolvency proceedings are opened. Well, the phrase that you will find in the pleadings against the subjective arbitrability would basically state that the matter is no longer arbitrable as the insolvent party does not longer enjoy full capacity, therefore the arbitration agreement is inoperable. So why the full capacity would be relevant? The full capacity is relevant because most of the jurisdictions in Europe, in continental Europe, refer to the full capacity of a party to enter into an arbitration agreement. So once that the party loses that full capacity, then it may be a problem with the operability of the arbitration agreement in that situation. It's almost like a person would partially lose its capacity because it is under a specific law, in our case, the insolvency law. Now, once again, territoriality of the law that would be of interest in this situation may differ. We may have the law applicable to the arbitration agreement, again, the law applicable at the place of arbitration, or the law applicable to the insolvent parties. All of them may have some sort of, I would say, argument that one can bring in order to assess the subjective arbitrability. And finally, the third most frequent argument that I found was referring to the legal standing, or the procedural capacity, as we call it in continental Europe, basically the capacity to stay in a dispute as opposed to the capacity to enter into a contract. And here, the most frequent pleading is that an insolvent company loses its legal standing in arbitration as it is restricted by the insolvency law. Now, once again, insolvency law, but insolvency law is normally the law applicable to the insolvent party, not necessarily the same law at the place of arbitration, namely the law applicable to the arbitration proceedings. These would be the main questions or perspectives from which the impact of the opening of the insolvency proceedings are pleaded, but we may have also different views as to the moment in which the issue of arbitrability or the issue of operability of the arbitration agreement or the legal standing are brought into discussion. And that may be before the arbitration is initiated or during the arbitration. If before the arbitration is initiated, an insolvency proceeding is launched, then the creditor may be pushed by the very tight deadlines under the insolvency law to file a claim into insolvency in order to preserve its rights. And that may be perceived as an action that would lead to that party losing the effects of the arbitration agreement, almost like a waiver of its rights under the arbitration agreement once that it did not prevail itself of that arbitration agreement but filed a claim in the insolvency proceedings. It may be also a matter of objection to the lack of jurisdiction or inarbitrability or the lack of legal standing that may be brought in front of the syndic judge as a type of discussion. And once that the syndic judge decides that it has jurisdiction, then, of course, it would be much difficult to open an arbitration later on because you already have a ruling from a judge saying that it has jurisdiction as opposed to the jurisdiction of an arbitral tribunal, and this discussion is usually taking place, if indeed parties wishes so, in front of the syndic judge. During the arbitration, as Manuel has already mentioned, we may have the situation of the stay or continuation of the arbitration proceedings that may happen also at the will of the parties, but also it may be a discussion that the arbitrators may bring in front of the parties. And then it's also the situation in which the creditor may choose to file the claim in the insolvency in parallel with the arbitration, with or without of the termination of the arbitral proceedings. So it may ask, for instance, to the arbitrator to stay the arbitration proceedings. He files the claim in the insolvency proceedings. At the end of the insolvency proceedings, it returns to the arbitration and see how this is developing further on. Why this is an interesting situation? It's an interesting situation because, at least in my part of the world, which is Eastern Europe, it has been a number of cases, quite a large one, I would say, in which insolvency were successfully leading to a reorganization, and that reorganization was getting the party back to business. So we had inarbitrability for a while, or stay of the arbitration, depending how the parties were approaching, and then back to arbitration. I had one case, it was really funny, in which we did that twice, because we invoked the lack of arbitrability. We discussed with the arbitrators. The arbitrators, went into some steps into that situation, and the arbitration continued because the syndic judge has declared that insolvency proceeding successfully terminated at the end of a successful reorganization plan. And then what happened is that while we were continuing with the arbitration, an appeal against the decision of the judge to terminate the insolvency proceeding has been filed, and the party was back into insolvency. And we had back to the objection, and the arbitral tribunal was once again in that situation. Now, I hope that at least I teased you with some of the topics that are on the agenda of counsel and arbitrators in continental Europe. And would you rather intervene now, or yeah, because I would.
I'm sure you have.
I'm sure to listen to you rather on this moment than
okay, that's fine.
on the new technology one.
Yeah, well, we can leave that point for later, because I think I would like to react to that a bit, in the sense that you have seen that Krenguta just presented different legal categories or legal labels that you can apply to the very same situation of insolvency, like affecting the arbitration agreement or the capacity, the arbitrability. That's an exercise under the conflict of laws approach of characterization, and that's certainly a very important exercise because it has very direct implications on the law that results to be applicable, and therefore it has an impact on the outcome. Now, there is no right or wrong answer. There's no prescribed characterization that prevails over the other one, which means from the point of view of counsel for party, and sometimes it is said as expert witness in a position in which I frequently find myself, as in international arbitrations, it's an exercise of reverse thinking. Where do you want to get? And then I'll tell you how you have to get there. That is, do you want to stop the arbitration or do you want to continue with the arbitration? And then we'll use one characterization or another characterization. Clearly, that's not an ideal regulatory solution, especially when you're playing with the money of an insolvent party, and the funds spent on a very expensive arbitration mean that unsecured creditors, employees, or public tax credits are not being paid. Now, in addition to those those options of arbitration agreement, capacity, or procedural capacity as well, that was mentioned, there are other avenues that you could potentially invoke, like direct application, regardless of any conflict of laws analysis, like mandatory rules, or public policy, or issues of overriding power that will have to be considered by the arbitral tribunal, regardless of the other categories. Now, a very clear reflection of that is a case called Electrim and Vivendi, which some of you might have come across if you've dealt with this. I was involved in that case as a very junior counsel when I was a law firm that was mentioned before, and part of the thinking was what category should we use in order to convince the tribunal or the national court at a later stage that was the right approach. What is interesting about that case is that there was an ICC arbitration in Switzerland, an LCA arbitration in England concerning exactly the same parties and a very similar dispute, and they reached very different solutions, whereas in Switzerland, both the arbitrators and the Swiss Supreme Court were convinced that capacity or subjective arbitrability was the right approach, and that meant that the personal law of the insolvent party was applicable. In that case was Polish law, and Polish law rendered the arbitration agreement ineffective. Whereas in England, it was considered that this was not a matter governed by capacity, it was a matter that affected the validity and effectiveness of the arbitration agreement. Therefore, the seat of the arbitration is England, Encanchap didn't exist by then, and therefore the law applicable to the arbitration agreement in that case was English law. We go ahead with the arbitration because there's no English prohibition of arbitration. So you could play with the arguments, and that's a reality, and that's actually why the IBA toolkit had a gap to fill, and I will go back to that in a second. But before that, all of this is motivated as well because, as we know, arbitrators do not have a very clear conflict of laws framework to resolve these matters, or, to be honest, any other matter on conflict of laws in general. Section 46 of the Arbitration Act is very vague, and when it comes to issues of conflict of laws, is quite free discretion for the tribunal very often. Now, from the perspective of English law, very briefly, what happens if an English company becomes insolvent? So the solution is that there's an automatic stay when insolvency proceedings are open in England, and that's called a moratorium. There are different types of insolvency proceedings, as you know, administration, winding up, or CVAs, or many others. You have them there, and I'm not going to go through them, but generally an automatic stay opens when insolvency proceedings commence in England. Two very important issues are that if an English company becomes insolvent, that moratorium can be lifted, and I will mention that in a second. But the other one is that moratorium does not have extraterritorial effect. That is, it's limited to arbitration proceedings or litigation taking place in England. That has not been regulated, but it's based on that decision by the Court of Appeal in 2009. Now, that's important. That means that if the insolvent party, the English insolvent party, has arbitration proceedings elsewhere, those arbitration proceedings are not affected by the automatic stay imposed by English law. Now, that didn't happen, at least in the European Union, with the European Insolvency Regulation, because that created an automatic recognition of insolvency proceedings in every other member state, and therefore that stay automatically was carried over to other member states. Now, the second thing, as I said, is that that stay can be lifted, and national English courts have developed quite a sophisticated list of criteria or factors to lift the stay so that arbitration can either continue or commence. And there are various considerations, like what is the law applicable to the substance? Does it make sense that the English judge or the English insolvency proceedings resolve that, or how advanced is the arbitration? What's the cost of the arbitration compared to the cost of resolving that in the context of insolvency? There are different considerations, and this is the case that you have there. Costco is one of the ones providing for that list of issues. Now, this is the judicial approach to a situation of insolvency here, and arbitration either here or elsewhere, that's in another jurisdiction. Now, the reverse approach is what happens with the insolvent proceedings have commenced abroad and the arbitration takes place in England. Now, before Brexit, if the insolvency proceedings were open in another member state, automatic recognition could potentially bring the solution of the regime provided by the home insolvency law. Now, post-Brexit, the key question is, has the foreign insolvency been recognized in England? And for that, we have in England the 2006 regulation, which internalizes a model law of UNCITRAL, which is not the arbitration model law, but the cross-border insolvency model law, which provides for recognition of foreign insolvencies. And Article 20 and 21 of that model law that has been adopted in England says that once we recognize a foreign insolvency, that triggers an automatic stay in the territory of the recognizing state. That is, if we recognize a foreign insolvency in England, every arbitration and litigation in England will be automatically stayed upon that recognition, although that stay can be lifted. Now, if there is no recognition of that foreign insolvency in the eyes of the law, maybe as a matter of fact, the foreign company is insolvent, but as a matter of law, that foreign company is not insolvent in England, and therefore there is no automatic stay. So one critical consideration that any of you will have to take into account, if you're in arbitration in England and you want to stay the arbitration, is don't focus just on pleading that to the arbitral tribunal. Go to an English court and request for the recognition of the foreign insolvency, and then you can use that automatic stay as an additional argument before the arbitral tribunal. But as I said, if there hasn't been any recognition, it is possible, A, to persuade an arbitral tribunal to go ahead with the arbitration, but second, even ask a national court in England to issue an anti-suit injunction to prevent litigation going elsewhere that contradicts the arbitration agreement seated in London. And that's exactly what happened in those two cases that you have there, on River Rock and Norrie Holding, where, for instance, River Rock concerned Russian insolvency proceedings with an avoidance action within the Russian insolvency proceedings that one party claimed violated arbitration agreements seated in London, and therefore that avoidance action had to be resolved in England in arbitration. Now, the English court was persuaded that whether an avoidance action in Russia had to be arbitrated in England based on an arbitration agreement was something that had to be resolved under the law governing the arbitration agreement, because it could consider as a matter of the scope of the arbitration agreement or arbitrability, and either of those two questions were answered under the law governing the arbitration agreement. They said that was English law, and English law allowed that claim to be arbitrated, and it fell within the scope. Therefore, an anti-suit injunction against the against the proceedings in Russia was granted. Now, however, that's not the approach or the solution that you will find everywhere else. In Singapore, the very same issue has been resolved in a completely opposite way. That is, the avoidance claim does not fall within the scope of the arbitration agreement. Therefore, there is no ground for an anti-suit injunction in those instances. So you have a clear collision of approaches between two very developed jurisdictions. And I think I will mention one more thing, and then, Frank Guta, you can discuss the point that you mentioned before. So one more practical point is who pays the arbitration? Or how can whether we can go ahead. I mean, these conflict of laws questions I just mentioned are very interesting, and sometimes they are very relevant, but they have as a prerequisite that parties are actually paying for the arbitration, otherwise arbitration may be suspended. Now, we know the institutional rules sometimes provide that if one party does not pay for the advance of cost, the other party can replace that, and therefore the arbitration can go ahead. But one additional question is, what happens, can we claim that the arbitration agreement has become inoperative as a matter or as a consequence of the impecuniosity of the party? And the English law, the approach is that that is not the case. The arbitration remains operative. But that is not the approach in every jurisdiction. In other jurisdictions, the arbitration agreement becomes inoperative. Now, Frankuta, you mentioned that all of this is not sufficiently complicated, so you wanted to add artificial intelligence and smart contracts on top of that.
Yes.
Right.
Well,
good luck.
Thank you. I couldn't avoid the topic because the biggest insolvency ever is happening right now in the blockchain area, is the FTX insolvency in the United States. So if we have the biggest insolvency ever, how we cannot speak about that? And for that reason, I wanted to highlight some of the future problems in the context of the blockchain technology. Now, you're going to ask me where one can find the blockchain technology in construction industry. Well, actually, it is quite already developed, and it will develop further on. First of all, it is a process of platformification, then a process of tokenization, and then we have the smart contracts. Platformification means that the contracting, negotiation, and the entering of the parties into the contract do not longer take place directly in a communication, do not take place in a market that it is that includes intermediaries, but it is based on an automated platform, and that platform matches the demand and the offer. This on the supply chain, it's quite frequent, and you will have a lot of matters of supply that would be impacting construction projects in this sense. Tokenization, what does it mean? It means basically that you would have some sort of deeds, I would say, that would be reflected in an electronic form, and that form might be based on a key, anonymous and based on a key, rather than individualized. If you remember I'm sure you do remember, but if you ever connected the topic with this one, the old promissory notes are pretty much reinvented in this concept, in which basically you have some sort of contractual relationship that is circulating at all moments. Bonds are entering here, etc. And smart contracts basically is an automated contract in which part of the will of the parties, namely that will of the party to perform or not to perform the contractual obligations, is to be automated. And basically the parties will not have the choice not to perform their obligations, because this will be automated and the performance would take place without any kind of choice of the parties to misbehave during the contract. Now, if these are the three main challenges to the legal system that are brought by the blockchain technology, what's happening in case of insolvency in all of these situations, and where is the place of arbitration in that case? Where, first of all, the platformification of the contractual relationship is basically increasing enormously the speed of transactions that may grow exponentially. And which means that you may have a contract that is rolled on the platform on such a speed that basically by the time that you decide to have a claim, by the time that you decide to have it against somebody, by the time that you want to serve a notice of dispute to that person, the contract has been transferred of thousands of times. Tokenization of rights creates, first of all, a problem of anonymity. Because, as I mentioned, it's almost like the numeric bank accounts, if you remember them in the history. So it's the same situation. Basically, you have access based on a key, but you do not have the identity of that, which is the owner of the actual right. And then how can you identify the status of an insolvent party if you don't know who the party is, if the party is identified by a key? Then, the due process in case of anonymity. Most of the legislations worldwide are reluctant into accepting a kind of proceeding in which the parties are not properly identified. There are some exceptions in criminal law, and where usually it takes about either securities or enforcement, but not necessarily a process in itself. And then the multi-party. The number of the parties may grow exponentially. At this moment, FTX, it will be like, millions of people that will be involved into the insolvency. Smart contracts, as I said, automated enforcement. Well, how you can suspend that contractual behavior if it is automated? in case of an insolvency proceeding, because as you mentioned, the insolvency proceeding has a moratory effect. I mean, it has most of the times it suspends the enforcement. It's not the purpose is not the enforcement itself, but rather a type of delay in which the party may cure the situation of the insolvency and move on with its activity if that is possible in reorganization. Now, all these are creating significant problems in the situation of insolvency. All these are to be found in the construction industries also because of the tokenization of the real estate, in which you will not have a contractual party that is a clear owner, but you will have a pool of people, almost like an investment fund, but not necessarily in the form of a legal entity. It may be that it is in the form of a general partnership, the so-called DAO, in which you do not know who is the individual member of that partnership, but you just have an anonymized situation of somebody holding a token, a participation title, if you want, into that organization, which organization has no legal personality. So for that reason, my proposition to you is the following. Since the future of our contractual relationship is so interesting and so complex, well, it has to belong to arbitration. Because simply arbitrators will be able somehow to solve these matters on a personalized way. Whenever you have something unusual, well, you do a procedure that it is unusual. Arbitration in the overall, if you think about it, before we had this separation of language, it is an alternative dispute resolution. Alternative to what? To the courts of law. But what are the courts of law? Basically, it's about standardized justice. So basically, arbitration is an anti-standardized or alternative to standardized justice. If we have something like this, a complex situation, a new one, I think it's good to look at arbitration as one of the options. Thank you.
Well, after that, I think it sounds promising, but at the same time, I mean, too complex for a Friday afternoon for me. But in any event, we have been very good at presenting lots of questions and not providing many answers. So just a bit of hope. So there are two projects at the moment that you need to be aware of if you are interested in on the interface between insolvency and arbitration. So one is by the Charter Institute of Arbitrators in coalition with the Judicial Insolvency Network. They have created a team, which I have the privilege to chair, to create a protocol whereby arbitration will be used to resolve cross-border insolvency matters. That is, using arbitration for cross-border insolvency. Now, we have had experience of major insolvency cases like the Lehman Brothers, the Nortel case, like major cases in which there were some clashes of approaches between the US approach, the Canadian approach, the English approach, and many of the subsidiaries of the groups. Now, what the project is trying to see whether we can create a supranational arbitration tribunal to resolve some of the issues concerning cross-border insolvency. So watch this space. We are working on it. It will come out maybe in a year's time or so. The other one has been mentioned already, which is the IBA Toolkit on Insolvency and Arbitration, chaired by the IBA Committee. And again, I was very lucky to be the chair of that project. It resulted on a toolkit, a publication by the IBA last year, which was awarded by GARD the Legal Innovation of the Year. And we put together national reports of 20 jurisdictions. Now we are working to add another 10, explaining all the questions that you can imagine about the interface between insolvency and arbitration. So they have reports of around 50 pages per jurisdiction, and you can consult them for free. But in addition to that, there is first, an explanatory report of around 70 pages, trying to provide answers to the questions that we discussed today, without the arbitration intelligence, or the artificial intelligence issues that you mentioned, and also a roadmap. So we attempted to provide a methodological framework that arbitrators will have to follow in order to resolve all these characterization questions that we discussed. So you can find that the IBA toolkit available online, and if you have any question about it, I'll be very happy to discuss that with you. Thank you. I don't have anything else to say.
Well, I was just planning to add one 10 seconds comment. I mean, you can see that I enjoy this part of law, and my colleague as well. So I think that you do as well. Well, problem is that parties don't. They just want a boring arbitration. For them, the ideal arbitration is the predictable and boring one. That's it. Now, this is not predictable, and this is not boring at all. Unfortunately, this is what the parties do not like so much, the interface between arbitration and insolvency. Thank you.
Well, thank you very much, both of you. That was absolutely masterful. So thank you. And for those of you who haven't looked at it, can I strongly recommend the IBA Toolkit, which if you want to know what the answer is to the questions, and obviously the answer is extremely jurisdiction specific, have a work your way through that. Let me turn then to using AI in resolving construction disputes, and to Professor Gerber. Professor Gerber has been an academic in the Monash University Law Faculty since 2004. She's an internationally renowned legal scholar with expertise in two distinct or apparently distinct areas of research. The first is international human rights law, and the second is construction law. One might have thought those two things were totally distinct until this year, when everybody's talking about the two things together. Professor Gerber researches, teaches, and performs leadership roles across Monash. Prior to moving into academia, she had a distinguished career at some of Australia's leading law firms, Maddox, and before that, I think Mallisons and Baker & McKenzie. The interesting fact, for me at least, about Paula is that although we weren't aware of it at the time, she and I think, were contemporaries at King's in 1991, which was the year of Murphy and Brentwood, which you're hearing about earlier. Paula was on the MSc in construction law. I was a second-year undergraduate. But let me pass over to her.
Thank you very much. I'm delighted to be here and to be talking about this topic. As you've heard from some of the other speakers, we were assigned our topics, and when I started discussing what I could speak about at this conference, I suggested women in construction would be a topic I'd like to talk about, and I was told no, they'd rather I speak about AI in construction dispute resolution, which I'm very happy about. I've got a second edition of my book on best practice in construction dispute resolution coming out next year, and this will be a new chapter in that edition. But I was just thinking about, when we were talking this morning and a bit yesterday afternoon about women adjudicators, that it might have been apt to have a discussion about gender in our industries and professions. I thought I might just spend a minute talking about why you've got this Aussie professor talking to you today. Go back to the mid-1980s. I didn't want to be a construction lawyer. I didn't want to work in London. I had interviewed with Baker & McKenzie in Toronto, and they had offered me a job in banking litigation. And they said, but it'll take us 3 months to get you a work permit, so go and work in our London office, and when the visa comes through, we'll send for you. Fine. I come to London, I'm working in litigation. 3 months later, the Canadians say to me, the last thing we want is more lawyers. We're not going to give you a work permit. So I say to Baker & McKenzie, I'm enjoying it here, can I stay? And they said, well, the only opening we've got is that we're setting up a construction law practice. Would you like to be the junior solicitor helping the partner there? And I said, sure, but I don't know a whole lot about construction law. And they said, no problem. There's a new Masters in Construction Law starting at King's College. We will pay for you to go and do that unit. So I was part of the very first intake into the MSc program, and I was so impressed with the course that when I went back to Australia, I approached the University of Melbourne and said, hey, I've got an idea for you. How about we have a Masters in Construction Law? And the second photo up there is Matthew Bell. Matthew Bell, like I was the first intake in the King's College Masters, was one of my first students in the Melbourne Uni Masters, and that is him graduating with his PhD from King's College, and he is the director of the Melbourne Uni Master of Construction Law program and taking it from strength to strength. I now teach construction law at Monash University, and here I am today. And I don't know quite what I did to deserve being the second last speaker on the second day of the conference. And I thought, I've got to find a way to engage the audience. Yesterday, John Uff said he's a traditionalist. I'm not. So I came up with the idea of a quiz on AI. And in order to get you to participate, I brought along with me from Australia some caramello koalas. So I thought Friday afternoon, chocolate will get them engaged. So let's see how much you already know about AI before I start talking about it in detail. And apologies to the people watching online. I'm not Harry Potter. I don't have any way to transfigure and transport you chocolates. So this is limited to the people in the room, if I can actually open the chocolate. So the first question, who came up with the term artificial intelligence? Oh, this is sad. No one? Okay, it was John McCarthy. He was an American mathematician, and he has actually hated the name ever since. And he said if he'd had his time again, he would have called it computational intelligence, not artificial intelligence. Given no one knew the first answer to the first question, I'm not confident about the second, but let's give it a go. When was the term artificial intelligence coined? I'll give a chocolate for the right decade.
1974.
Oh, too late. It was actually, the term was developed before I was born, before Anns and Merton, before Dutton and Bognor Regis, before the FIDIC suite of contracts. Anyone want to have another guess?
1947.
We're in between the two. It's actually 1956 was when the term was developed. All right, how do we define AI? What does it mean? Come on, I lug these chocolates all the way over from Australia.
I think the koalas are safe.
All right, so it is a computer system which behaves and appears intelligent. While there are numerous definitions and interpretations, the core idea of AI involves machines mimicking human intelligence to perform tasks and improve themselves iteratively based on the information they collect. Okay, feeling less confident with every question. What is machine learning? Yes? I'm going to give you a chocolate for that. I like the idea of throwing caramello koalas around the Great Hall. I suspect it's never been done before, but maybe Dean Dan Hunter will take up the idea. I can leave some chocolates I haven't given away with him. Yeah. There are two types of machine learning that we refer to, supervised and unsupervised. So supervised is where the machine needs the human training about what's the connection between the input and the output. So an example of supervised learning would be your Netflix recommendations, for example. Unsupervised learning is where there's not the human training. We're just going to give you all this data and we want to see what patterns and similarities you develop. So they might say, here are all the people who bought Ferraris in the last 5 years. Tell us what patterns you see, middle-aged white men living in Kent or whatever it might be. So it doesn't need to know what the outputs are that you're trying to get to. All right, what is the Turing test? Yes?
That's when an individual is allowed to ask questions of a machine or an interface.
Yes?
And if they are able to identify that it's not a human on the other side, then it's failed the test.
Yes, pretty much that's right. So there are three machines. There are three machines. Two are operated by humans, and one is asking the question. The other two are physically separated, and they're both answering the question. And if the person asking the question can guess that it is, whether it is a human or machine that is answering more than 50% of the time, then that's considered artificial intelligence. All right, I'm more optimistic about this question. What was the name of the computer that beat the reigning chess champion Garry Kasparov in 1997? Deep Blue, did I hear? Yes. Love it when people in the front row get it. It doesn't challenge my throwing skills too much. Okay. What is the acronym TAR short for, T-A-R? Oh, I thought this was a gimme. Very good, thank you. Technology assist review. Well, that's going to test my throwing. Close. All right, which two countries already have AI judges? I'll give a chocolate for one. No, alas, no. No. Where's that? Getting in the right region. China. Who said China? Okay. China and Estonia is the other one, which is a bit of a surprise. They're using it in their small claims court. Okay, here's a true or false question. An AI model has been developed to predict the outcome of construction litigation. True or false? True. Who said true? Here we go. Can you tell me which country it was done in? Okay, it was the United States. It was in Illinois in 2002, and they used case-based reasoning to predict that. That's the next question, but I think 83%. 83%. Well, and that brings me to a similar test was run for the US Supreme Court. Can we predict the outcome of Supreme Court cases? And they asked humans, and they got 59% accuracy. What accuracy do you think AI got? 90%. Close, 70%. More than humans though. But, and I'm going, oh my God, like you, what are we doing here? Let's just all hand over to computers. But in fact, it's rather depressing when you realise on what basis they predicted the accuracy. There were 5 categories of information. The circuit court, so was it from California, was it from Florida, was it from New York, etc. The field of law, so was it criminal law, labour law, construction law. The characterisation of the parties, banks, consumers, etc. Possible political bias, in the decision of the lower court. Was it a conservative court? Was it a liberal court? And the final category that they looked at was, did the issue relate to a question of constitutionality? So there was no applying law to the facts. They used those 5 criteria and got a more accurate prediction than the humans. All right, I put in a couple of bonus questions to see who was listening yesterday. So nothing to do with AI, this is just a revision question, or 2. What did Justice Waxman identify as a leading cause of construction disputes? Yes. You're an Aussie, you don't need one, but there you go. And then, final question, how much did the value of construction disputes increase between 2019 and 2020? 65%. Who said what? 60%? No, it was more than that. 75% is correct. Okay. Oh, bad throw. Oh, good deflect though. All right, that's the end of the quiz. Now let's get on to the substance of what I'm going to talk about, and I'm going to start by saying what I'm not going to talk about, because AI is a huge field, and there are many aspects that I could talk about. Smart contracts, blockchain, the digitisation of construction projects are all aspects of AI that could contribute to a reduction in disputes. But I'm here this afternoon to talk about dispute resolution rather than dispute avoidance. So I'm not going to talk about those. Not AI, but I do want to acknowledge the enormous technological advances that the COVID pandemic has produced, certainly in Australia. In Melbourne, we had 284 days of lockdown or something like that. So we very quickly pivoted to video hearings and e-courtrooms. Discovery, TAR, is an area where AI is being used. I thought flying over from Australia to talk to you about discovery was just too boring for words, so I'm not going to talk about discovery. What I am going to talk about is 2 questions, and that is, can AI make better decisions than human judges? And can AI replace human judges? So let's take each of those in turn. One of the reasons that advocates for AI as replacing human judges is that human judges and human beings in general are flawed. We have our biases, we have our prejudices, and that our decisions suffer from unconscious bias, and that algorithms, being mathematical equations, they can remove all those sort of factors of subjectivity that a judge might bring to a decision making. But, and it's a very big but, all it is doing is substituting the bias of the programmers for the bias of the judges. Because it is the programmers who decide what data is going to be fed into the computer. And what we have seen in America is that it results in enormous prejudicial decisions being made. And many police departments in the US have stopped using AI because if African Americans have historically been arrested by police more often than white Americans, and we know that's the case, and you're putting into the machine to learn the mugshots of all the people who've been arrested, then AI is going to spit out that your offender is more likely to be a black male. So we are not getting away from prejudice and bias. It's just coming in a different shape and form. And they've actually developed a name for this. They've called it the feed-forward loop, because you are historically repeating the mistakes of the past. And this is very, I think, clearly articulated in this graph, where we're looking at facial recognition technology. And you can see that there is, at a minimum, 20% differentiation or inaccuracy between black women and white men facial recognition, up to a maximum of 34% with IBM. And so that is something that I'd suggest we cannot tolerate in judicial decision making. So I don't think that AI makes better decisions than human judges. That's not to say AI doesn't have its place and make better decisions in other areas. And certainly in the medical field, we are seeing huge advances and huge increase in the accuracy of diagnoses, because AI can have this wealth of data about millions of different medical conditions and come up with more accurate decisions. So the other aspect that I'd say is a problem with AI and why it doesn't make better decisions with judges is that all the data it is being fed is from the past. So AI is only as good as the data that's inputted into it, and so it's being trained to think and act like judges in the past. That allows no room for the common law to evolve. I'm going to use a case study of that from actually Frederick Wilmot-Smith already talked about this case this morning in his presentation on quantum merit, but the long-standing position in Australia until very recently was if an owner repudiated a contract, the contractor got their pot of gold, as we'd call it. They got to claim on a quantum merit basis, regardless of what the contract said. The contract price was not relevant in the calculation of quantum merit. There's a lot of criticism of that, but it was a long-standing precedent. And then along came the decision of Mann and Patterson in 2019, and the High Court said, whoa. Actually, if you have a contractual right to payment pre-repudiation, that stands, and that's going to be the basis of your calculation. If no contractual right to payment had accrued prior to repudiation, yes, you can claim quantum merit, but the contract is going to act as a cap or a ceiling for the amount that you're going to recover. Now, if AI had been asked to make a decision on that case, based on all the data inputted on previous quantum merit cases, it would have reached the opposite decision. So can AI make better decisions? I'd say it is reliant on sophisticated statistical algorithms that don't reflect real-world data, all they can do is digest the binary data. So for AI to be useful, the problem must be defined in a way that is amenable to a simplistic binary decision of yes or no. So there may be a role for AI in resolving disputes about traffic offences, or what the penalty should be for someone driving under the influence, because there'll be large quantities of very repetitive data. But the one thing that we all know about construction disputes is they're rarely simplistic, and I don't think, therefore, they amend themselves to AI making a better decision than a human judge. So then that leads me to the next question: can AI replace judges, human judges? And spoiler alert, the answer is no. And I'm going to give you 3 reasons why I think that's going to be the way of the future, that we're not going to see AI judges. So the infinite variety of the differential facts that we see in construction cases, the lack of reasons, and a violation of human rights. So as I've pretty much already said, AI requires this binary coding, black and white input of data to produce absolute outputs. But the real world situation is very different. And AI can't replicate the knowledge that humans acquire over long-term experience and engagement in the real world and in construction disputes. So it's not possible to reduce complex construction cases into the sort of answers that AI can produce. The second reason I think is even more important, and that is the lack of reasons. I recall when I sat as a tribunal member at the Victorian Civil and Administrative Tribunal hearing building cases for 10 years, and we have a very good judicial college that provides training to new members of tribunals and courts. And one of the things that they advised me very early on, which always stuck with me, was write your reasons for the benefit of the losing party. They need to understand why they lost. And there's been a lot of research that's been done that says a losing party is likely to accept the decision, even though they lost, if 2 things are satisfied. One is they feel they got a fair hearing, they got the right to present all their arguments and their evidence. And the second thing is if they understand why they lost. And AI fundamentally can't provide reasons. All it can do is to say, the algorithms spit out this decision. And the algorithms are really a black box that it's very difficult to penetrate and to see and to understand. So computer scientists might be able to unpack it and understand why it got to that decision, but a lay litigant appearing before the AI judge would not be able to understand. And as recently as 2015, we had the decision of Waymont and another against Place, where the court overturned a lower court decision because of the lack of reasons. They said parties are entitled to have explained to them how the judge has determined their substantive rights, and for that purpose the judge is required to produce fully reasoned judgment. An important aspect of this process is the production of a properly reasoned judgment which explains to the parties and to the wider readership why the judge reached the decision that was made. This includes making a reference to the issues in the case, the legal principles or tests which have been applied and why, and to indicate how they resolved conflicting factual evidence, how they came to accept the evidence of a particular witness. And in this case, they just, the lower court judge, the trial just accepted all the evidence of one party, rejected all the evidence of the other party without any explanation, and that was subject to being overturned. As you heard in the introduction, I do have 2 areas of law that I specialise in. The second one is human rights. I'm fangirling a bit here with Michael Kirby, High Court recently, not that recently anymore, but retired High Court judge who was a fierce advocate, is a fierce advocate for human rights. He was often referred to as the dissenting judge because of his willingness to refer to international human rights conventions in reaching his decisions. Australia is the only Western democracy in the world that doesn't have a Human Rights Act at a federal level. Victoria has a Charter of Human Rights, Queensland recently enacted a Human Rights Act, but there is no federal national human rights legislation, so we do have to rely on international conventions. We also are the only region in the world that doesn't have a regional human rights treaty. So you've got the European Treaty, Convention on Human Rights, there's the American, there's the African, there's no Asia-Pacific Human Rights Convention. Anyway, Article 14 of the International Covenant on Civil and Political Rights says that everyone shall be entitled to a fair and public hearing by a competent, independent and impartial tribunal established by law. And Justice Kirby has raised very significant questions about whether AI adjudication would conform to the requirement that disputes in the court system be openly and publicly adjudicated. So, quickly coming to an end, there is no computer and none on the drawing boards that I know of which can be programmed with the will to do justice. A judge's role is not simply to deliver an outcome, it's to deliver a just outcome. And AI is very good at efficiency, but it can't guarantee quality, it can't guarantee a just outcome, and it can't deliver a public hearing. So, what does all this mean for construction disputes? I don't see a future for it. The lack of reasons, the lack of the ability to verify the basis for a decision and therefore to appeal a decision from AI is simply not there. And perhaps a bit dramatic, but I draw the analogy that we abolished the death penalty because the consequences of an erroneous decision were too great. And I think the same is the case with AI. There's potential for erroneous decisions that cannot be corrected on appeal. So, a couple of final thoughts. I think I've pretty much said everything that's there. Parties need to feel that they are getting a just and fair hearing. I don't think AI can provide that. A quote from Tanya Sourdin, who used to be at Monash University, is now the Dean of Newcastle Law School, the Newcastle in New South Wales, not in the UK. She says, the role of the human judge, though, is not merely that of a data processor. To reduce judging to such a definition would be to reject not only the humanity of the judge, but also of all those who come before them, the parties themselves. And the very final slide, AI can support the resolution of construction disputes. It cannot replace judges. So what we're seeing, and what I think we will see more of in the future, is a machine that might be focused on a witness and measure their body temperature and their body language and their speech patterns to work out if they're a truthful witness or not, and maybe that will assist the judge in reaching their decision, but it certainly won't replace judges. So my final concluding thought is I don't think AI decision-making in courts is something that we're going to see anytime in the future. I don't think it's going to work. Going back to the start of my presentation, I do think having more women in construction and in the construction legal profession will work, so I'd like to talk about that if I get another invitation to come back. Thank you.
Thank you. Thank you very much, Paula. Then let's move to our final speaker. Dr. Baltag is an associate professor in international arbitration at Stockholm University. He has been an attorney at law since 2004, with extensive practice in, amongst other things, investment arbitration. She's the director of the International Commercial Arbitration Law LLM at Stockholm University, a member of the board of the Arbitration Institute of the Stockholm Chamber of Commerce, and has been appointed as arbitrator or legal expert in numerous arbitrations under the rules of all the major institutions. Importantly, for the purposes of the topic that she's going to be speaking to today, she recently co-wrote with Anna Sanic a book called The Future of Investment Treaty Arbitration in the EU, Intra-EU BITs, the Energy Charter Treaty and the Multilateral Investment Court, which is published by CLUA. Dr. Baltag also recently sat on a tribunal for the young EFILA debate on whether the EU remains an attractive investment destination in the wake of Acmea, Comstroy and PL Holdings. She's going to be addressing you on the future of construction investor-state dispute resolution. In a world where we read daily of the exodus, or in fact stampede, from the Energy Charter Treaty, her work is, and her speech is extremely well timed. So, Karina, let me pass over to you.
Thank you very much. I do not have Paula's Candice, and I do have the task of being the last person standing between you and Professor Nazini's final concluding remarks, and of course the drinks at the end of back of the room. But I do appreciate again the collaboration between our universities and to be here on such a special occasion. This morning, Luxembourg announced that it is going to leave the Energy Charter Treaty, just to keep you updated on what is happening in the field. But I wanted to kind of put a thread between the presentations of this panel and just to pick up one point from Paula's presentation on the fact that AI cannot deliver reasons or reasoned judgments. Actually, in investment arbitration, some of you may know that under the ICSID Convention, the Convention on the Settlement of the Investment Disputes between States and Nationals of Other States of the World Bank, a reason of annulment of the arbitral awards is failure to state reasons. So we are also done with that in investment arbitration. When it comes to insolvency, investment arbitration in particular, when it comes to construction, projects have seen a lot of the developments, and I agree with the comments of my dear colleagues that each case is a new situation. I can give you a recent case. I was involved as an assistant to the arbitral tribunal, where the claimant was the bankruptcy, the insolvency of the claimant was generated by the respondent state, or allegedly generated by the respondent state in the arbitration. And the main creditor of the investor, of the claimant, construction company, was the state itself. So you're in a situation where the respondent has the interest of prevailing in the case, but at the same time an interest of not prevailing in the case because it wears double hats. That was of a creditor and also that of a respondent accused of breaching an international treaty. With respect to construction disputes, of course, nothing that was said in these 2 excellent days is different. We have major construction projects. The difference is that these construction projects are cross-border. Of course, the value is very high. We're talking about hundreds of millions, sometimes billions. Traditionally, what we've seen in investment arbitration from construction of bridges, recently in Garanti Goza versus Turkmenistan, construction of airports, Fraport versus Philippines, renovation of hotels, Alpha Project Holding versus Ukraine, or the construction of important railway in Armenia, in Boriskovsky versus Armenia, which was, or it was supposed to be part of the corridor connecting Moscow to Mumbai. And that was a $3 billion project. What I think is important to stress when it comes to construction projects and investment arbitration is the fact that unlike construction in the commercial sphere, the political interest is obviously more prominent. And there are different types of contracts, construction contracts, the ones where the state or its state entities are not involved, but the state, by its action, for example, failure or refusal to issue a permit on or construction authorization, generates a breach of an international investment treaty. And there are contracts where the state has an interest in the contract, wearing a commercial hat, as we say it, either by its government, local entities, or any state-owned companies. And there is the problem of distinguishing whether the conduct of the state, broadly speaking, in that contractual setting can be attributed to the state in its sovereign capacity. So there are a multitude of situations that we see. The distinction between construction projects in investment arbitration and other types of investment disputes is the fact that investors, usually the construction companies, cannot pack their bags and leave the country and relocate their business in another place. The construction project is meant to be in that jurisdiction. But in the past 2-3 years, we've seen obviously the COVID-19 pandemic affecting also construction investment disputes. Also the fact, as a consequence of COVID, the fact that global FDI flows fell dramatically. In the second quarter of 2022, we had 7% less FDI flows than in 2021 during the same period. And greenfield project in construction fell by 30% in 2022. Surprisingly, in countries like China and India, FDI flows increased. So this is something that we have to keep in mind. But probably the most important development in the past years is as we discussed yesterday, and we had an entire panel discussing the carbon zero and construction, and of course the comments of Kim Franklin on the ESG, is the transition to a clean energy. Just to give you a perspective of how many investment claims related to construction projects are or have been submitted between 1972 and 2022. Out of 875 arbitration cases before the World Bank ICSID, 10% were construction disputes. But this doesn't say anything about energy projects, because those are put in a separate category, which is oil, gas, mining, electric power, and other energy, totaling 42%. And here we can have construction disputes related to the energy sector. Transportation makes up 8% of these arbitrations. Here as well, we have construction disputes, which are part of this percentage. Water sanitation, 4%. Here as well, we have construction projects. So the reality is that we have more than 10% or more than 90 arbitration cases involving construction projects. Just to give you an example, Nord Stream versus the European Union, a very important case at the moment for the Energy Charter Treaty and for the security of energy in Europe, involves a construction project in the energy sector. What are the types of these construction projects in the energy sector, you might ask? Well, typically from laying of pipeline, construction of power transmission, construction of power plants, refineries, LNG facilities, development of port facilities for LNG. Julian was mentioning earlier the development of solar and wind farms. So quite important construction projects we have in the energy sector. So why is this important in the transition to a clean economy? A fight against climate change, very important. We heard the Energy Charter Treaty, a very important treaty which is not limited to the protection of investments in the energy field, is more than that, is on transit and trade in the energy sector, is currently undergoing a modernization, or if you want to call it simple, an amendment process, the approval of which will happen next week on 22nd of November. Why is the treaty important? It has significant contracting parties, the European Union, all its member states except for Italy, and it has the Central Asian states, Turkey, Japan, very important for East-West energy security. Why is the Energy Charter Treaty important in the context of construction disputes? Because, as you could hear, construction projects in the energy sector are significant, necessary, and of course they will be affected by the future of this treaty. The Energy Charter Treaty defines economic activity in the energy sector as being the exploration, extraction, refining, production, storage, land transport, transmission, so on and so forth. And then it explains that this includes construction and operation of power generation facilities, including those powered by wind and other renewable energy resources, construction of grids and pipelines, and decommissioning of energy-related facilities. Why again, the future, let's put it this way, of construction disputes in the investment context, but we focus on energy and the transition to a clean economy, to a clean energy in the context of the latest economic developments and also the geopolitical situation. Of course, the Paris Agreement imposes strict obligations. The states have already started to implement certain measures. Germany and the Netherlands, just to give an example from here, decided to phase out the fossil fuel investments immediately, with immediate effect. We have notable investment arbitration arising of this phase out. We also have, as far as Canada as well, recently the province of Alberta passed a similar legislation as the Netherlands and Germany, which resulted in a very interesting case, and other legislation, of course, passed. Another very interesting case, Trans-Canada Pipelines versus USA, on an application to the US State Department for a presidential permit to build the Keystone XL pipeline from province of Alberta to Nebraska, whereas the US Department of State refused to issue the permit because of the significant impact on climate change of such project. So we are going to see this more and more. The Energy Charter Treaty in the amendment form provides for a phase-out of fossil fuel energy investments, but not with immediate effect. For the existing investments, there will be a 10-year period after which the protection of the Energy Charter Treaty will expire. And certain construction projects, in particular related to pipelines, they will be able to survive a bit more if they comply with certain requirements. My take on this, we're going to see probably more disputes involving the construction projects related to energy investments in the fossil fuel or related to the fossil fuel energy with immediate effect, and depending, of course, of what will happen next week with the Energy Charter Treaty. In the long term, probably we'll see less such disputes. We'll see more investment disputes related to renewable energy, probably to the construction of hydro power plants and dams, wind farms, and solar investments. So this certainly will conclude in a very positive note our panel, to say that there's still work for us in the arbitration, including in the investment arbitration field. Thank you.
Now, we do have 4 minutes before Renato is due to give his concluding words. I don't know if anybody has any questions arising. Yes, we already have several questions arising out of what's been raised. Okay.
Thank you, that was fantastic. My name is Kavita Mohanty. I'm an Indian qualified advocate, and I finished my Cambridge LLM. Professor, you made a very interesting point, and I hope I don't get sued by the parties in the future, that parties are the primary issues and they want predictable and boring dispute settlement, right? But now with the whole war situation, and as we can see that Russian parties are now trying to have a seat in Singapore, and even in India, when I was practicing, I saw that more and more parties are going, given the geographical proximity, so to speak. And with the whole Brexit thing, I want to understand from a counsel's perspective, as opposed to an arbitrator's perspective, that what are issues that we face with our clients, and to make it a seamless process for our clients, because there clearly is a conundrum between clients wanting, say, for instance, a boring dispute, as opposed to us making sure that we can facilitate between arbitrators and be the linchpin between clients, right? How do you still continue making London one of the most prominent seats, given that now everybody has so many options to go everywhere? I'd love your response on that. Thank you.
Thank you for addressing this question to me. That is a challenge, I would say. Well, actually, I wrote something this year in the important communication report on the status of UK justice. Sorry for having this daring opinion, but I had a great admiration for the way in which this country has developed its adaptability to the new technologies. So I saw a number of initiatives taking place here in UK, which were amazingly modern and advanced, also for blockchain technology, also for the technology-related disputes. And to me, these kind of initiatives are the advantages, I would say, that are placing at this moment the UK community, legal community, both the state justice system, but also the arbitrations that are based here in the forefront, I would say. I was, on my side, quite impressed, at least by two documents that I noted. One was the 2021 launch of a national AI strategy, where actually I read at that time that the UK government announced a plan, a 10 years plan, to make Britain a global AI superpower, which was interesting to see. And then I also noted that it was an open innovation team in place, where the Civil Justice Council launched the Futures Working Group. And here, what I read, and I have the quote because I quoted myself, was like this, that the scope of this work is to take and encourage a long-term view on the impact of technology on the administration of justice, with emphasis of increasing access to justice and security of the position of the legal system of England and Wales as a global leader. To me, it was an amazing declaration, because I saw a country who wanted to promote the legal system as one of the ways to promote the country itself worldwide. So to me, it was something that I keep on quoting to my students. Look how the justice system may be something that important that may be considered one of the key elements for a country to stay in the top of international community on the nowadays extremely diverse environment. So thank you for bringing this to me, and I apologize for everybody who is more entitled than me to issue such an opinion. I just wanted to highlight this because it impressed me.
There was one further question at the back, Renata, if you'll permit us, and I'd be very happy to speak to you about your question, which is a very interesting question, and I know the Master of the Rolls will be delighted with your response, Gringritza. Yes.
My question goes to Professor Gerber. This is Jason here, King's College LLM student. So you mentioned that considering that there is AI judges, which may have the limitations that you set forth, what is the possibility, or is there research going on AI lawyers, wherein you put a set of inputs or data and comes out with an argument, and the question is, who comes up with a better algorithm? If so, then most of us are going to be unemployed in the near future. So what should both lawyers, young and mature, to stay more relevant in such a dire future? Thank you.
Great question, and I would say that there is a lot of role for AI to support lawyers as well as to support judges. So there was a decision in the US not that long ago on a costs order, and the judge disallowed a big chunk of the costs that the successful party was claiming for research, because the judge said you could have done that far more efficiently using AI. So I'm not going to reward your inefficiency by not using AI for your legal research. AI is also being used by lawyers to try and predict the outcome and use that to achieve settlement negotiations. I think that suffers from the same problem as using it to predict, the outcome of the case. But I think there is a role for AI in lawyering. We need to be careful. I mean, one recent study showed that a AI could write a student's essay on the importance of different learning styles of students. And the essay did very well. And then they said, programmed AI to mark the essay. So you had the student submit the essay, AI submit an essay and AI mark the essay, and no learning was done. So we need to make sure that AI doesn't, remove all the learning and knowledge that lawyers bring to the table.
Well, might I ask you to express your gratitude to our speakers for their tremendous contribution this evening. Thank you very much.
Thank you very much, Alex, and thank you to the speakers and everybody who is online. Still, there are no questions online, so clearly people have run out of steam a little bit, but we still have many participants online. Thank you very much for staying with us for so long, and to everybody here. I am really the person between everybody else and the drinks, so in the next hour or so, I will just summarize. You spotted the joke immediately, sorry. No fun there. So it was easily spotted as a joke. Fine. So, so really, I mean, by way of a very, very, very short conclusion, I would like to pick up on one thing about women and diversity. I think it is true that I asked you to speak about AI. But obviously, particularly after what you said this evening, we are going to ask all the speakers, not as a condition for speaking, that's why you know it wasn't, but to provide written papers for a collection. And Paula, I take that you will provide 2 papers, one on AI and one on women in construction, which is, and of course the written paper is much more important than the speech. I know this morning it was said that Latin confuses. I find Latin always very clear. So. Verba volant, but scripta manent. So, you know, words fly, but the writings stay, writings endure. So 2 papers for you. Thank you very much, Paula. You can't say no now. And as we discussed yesterday, we at King's with the Adjudication Society, based on our report, on adjudication, but not only on adjudication, more broadly in relation to the construction legal professions, will take forward from January initiatives on diversity. And I'm particularly pleased, of course, that on this panel there are 3 women, a number of academics, so 3 professors, because, my colleague Manuel, of course, reader, and Krina, also 2 graduates from King's. So it's an excellent panel to end the conference. We had very intensive one day and a half, competing yesterday with Texas. I just want to say thank you to everybody. I think the conference has demonstrated. There have been so many substantial papers, but many of them also made reference to King's, to the Center, to the MSc, to so many people who have participated in one way or another to the course, to our research, to our projects, and continue to do so. So many alumni, I mean, Paula is of course one of them, many of you in the audience and online, so many students as well, and I think also by looking at this panel, I mean, Paula, Manuel from the law school, I mean, from colleagues coming from Stockholm, from Romania, I mean, this is really a testament to the fact that we will continue to do what we have done for 35 years, so engaging with the construction profession and industry in London, which will remain, by the way, the leading seat for arbitrations and construction arbitration. That's another matter, but also certainly, as far as we are concerned, rooted in the English legal tradition, surely, but as we have always done, looking beyond to Europe, notwithstanding Brexit, and to the world, reaching all the way to Australia. I mean, Paula mentioned Matthew, of course. Matthew will be here, as you probably know, in January and February, and we will, having been a PhD student with us, now will contribute. Perhaps he doesn't know yet, but to the MSc. That's what happens. People are drawn into it before even they know it. But really, without saying anything else, thank you very much to everybody, and let's enjoy a Friday evening drink. Thank you.